good morning, good afternoon, or good evening, wherever you are in the world. Thank you for joining us for this webinar as organized by the Asian Institute of Alternate Dispute Resolution, supported by the China Maritime Arbitration Commission. I take this opportunity to thank all of you all for joining us, and more importantly, also to thank my fellow panelists. I'm actually supposed to be moderating this, but more likely I'll be joining in as a panelist to actually discuss this important webinar where we're going to talk about dispute prevention and resolution on the Belt and Road. And my name is Sundra Rajoo. I'm the president of the Asian Institute of Alternate Dispute Resolution, that is AIADR. And I have with me Mr. Philip Young, Dr. Hu, and Dr. Mohamed Abdel Wahab. So I'm going to first do a general introduction of them, and from there I will move on to give an introduction about the Belt and Road and also what we are going to cover. And it will be an interactive session. So one panelist leading. After that, we will all join in to give our views. Mr. Philip Young, I think a lot of us know him in India particularly, and he's very well known also in the rest of the world, particularly for his work in maritime arbitration. I've known him for more than 30 years. Since I was a novice. So he has been my mentor. And I think he's well known as a person who's from Hong Kong as the honorary chairman of the Hong Kong International Arbitration Center. Considerable work put in by him. He's also a vice chairman of BIMCO. I think he opened up BIMCO to actually bring India into the fold. And I think I know him as my role model for writing books. And he will always go through, he has written a number of forwards for my books, and he is one of the kindest, most meticulous arbitrators I've met. I then like to introduce you to, of course, I must add that one of the most experienced, all the panelists we have today are very experienced arbitrators, and they have done work in many parts of the world or in their region. Dr. Hu, I first met him when I became director of the KLRCA at that time, and he came to visit me in this ramshackle bungalow that we had, and this is the first time in 2010. Dr. Hu ever since has become a very close friend, and he's also vice chairman now of the China Maritime Arbitration Commission. Before that, he was a commissioner of CTEC and also vice chair of the ICC China Commission. He has done a former secretary. He was also a deputy secretary general of CTEC between 2010 to 2020. He has done numerous arbitrations and he has sat on ITSIC investment panels, and he has written a number of books. He's got considerable knowledge and information about what happens in China and outside. And of course, we come to our representative from Africa and also Asia. I always say that Professor Dr. Mohamed Abdel Wahab is a founding partner of the law firm Zulfikar and Partners, and I think all of us know him as a prolific thinker in arbitration. Particularly, he also holds the chair of private international law, and he's professor of international arbitration in Cairo University, one of the finest in our part of the world. So I think I mean, if I read out all his memberships and accolades, but I must say something about his accolade. The most recent, he is the African Arbitrator of the Year 2019, and he has been the leading Egyptian arbitration legal practitioner 2017 and 2018. Every year he wins an award. I'm just waiting for this year which award he's going to win. So We have a stellar panel, and let me just start with a brief introduction of what this Belt and Road is. And one thing is that when it was first announced in 2013, I was director of KLRCA, and my imagination was fired. When President Xi actually came to, I think at that time, to Indonesia, and he also spoke in Kazakhstan. Two speeches that actually mirrored and supplemented each other, and he came up with this concept of what is called the One Belt and One Road. At that time, it was called, and now it's of course changed into the Belt and Road Initiative. I suppose One Belt, One Road. He wanted to make it as an initiative, and this program or this initiative was bigger than the Marshall Plan, bigger than anything that we have seen in terms for Asia. I think this is the first time we saw something for Asia, said in a very concrete way, building on historical precedents, and in reality involved massive amounts of investment and also interweaving with various jurisdictions and the building of ports, railroads, roads, power plants, just quite massive. I suppose, when you go to China, I went to China the first time 20 years, maybe in 2009, in the 90s, and I saw the kind of development that was going on. And now if you go to China, you see the cities are all complete. They are all very distinct. So, I can see that vision that is coming out. And of course, it involves 70 over countries now, and you're talking a lot of money. And of course, it's also controversial in certain places, but in reality, I think it's mostly welcome. Everybody has signed up, and we need to actually think about some of the issues that are coming up. Of course, there are number of roads they talk about. They talk about the Silk Road Economic Belt. They talk about the 21st century maritime route, which is going through Southeast Asia. They talk about the Ice Silk Road in the Northern Sea. And then they are talking about corridors, economic corridors. And then they are talking about hard infrastructure, which includes roads, rails, ports, and all these things. Then they're also talking about soft infrastructure, which is trade agreements, common commercial and legal structure. So I think we are interested actually in the soft infrastructure. What is this soft infrastructure? And then today's talk and discussion is going to actually cover three main topics we hope to cover if we have enough time. First is the legal systems in the BRI. How is it going to be a challenge to actually have one legal framework, or how is it going to actually merge together? What will be the safe seat principles that come into that? And then which of the legal systems, because we have China, a common civil law system, how is it going to be adjusted to the BRI? Then we are going to discuss the role of arbitral institutions. What will be the emerging structures of ADR institutions, especially? Will it just be arbitration, or will it just move on to ADR? Will there be new institutions? What kind of measures these institutions will take? I think one of Philip's favorite topics, and mine too, what are the educational and training requirements that will be foisted or required to carry out this massive focus, and then where the training should be held and how we are going to hold it, and who will be conducting it and who will be accrediting it. There must be some standard. And then is there a need for some uniformity? I think that's the first question that we have to answer. Then after that, we will move on to the role of dispute prevention and ADR. Will dispute prevention be a priority? Because given now the Singapore Convention coming in with mediation, will mediation actually be more important than arbitration? And what will be the role of arbitrations in the BRI? And then how are we going to manage? How are the various jurisdictions going to manage, or is there going to be a supra arrangement? And finally, we have to look at COVID-19. I think all of us are affected by this. What is the impact of COVID-19 on the BRI projects? I know there's a lot to talk about. So can I invite Dr. Mohamed first to actually talk about the first topic, and then we will weave in. Thank you, Dr. Mohamed. Oh, you have to
Yes, no, it's okay. Hello, hi everyone. It's a pleasure to be in the presence of Datuk Sundra Rajoo and my esteemed colleague, Mr. Philip Young and Dr. Hu. Again, delighted to be part of this. I just wanted to start. The BRI is a colossal initiative, and the facts now show, as Professor Rajoo has mentioned, that we have almost 138 states that have joined, and this is based on latest statistics as of March 2020, based on the MOUs that China has signed. This includes 38 sub-Saharan African countries, 17 Middle East and North Africa countries, 34 European and Central Asian, including 17 members of the European Union, 25 countries from East Asia and the Pacific, and 6 from Southeast Asia, and 18 from Latin America and the Caribbean. So it can't be more global than this. And as we know, there are two main corridors, one that is a land corridor and one that is a sea or a maritime related one, with several or more than 6 corridors worldwide connecting the world. The initiative, as coined by President Xi in 2013, and now called the BRI instead of the OBOR or OBOR, is colossal. And I want to be more practical about it in terms of the legal systems involved. Broadly speaking, on a macro level, we can think of the legal systems. First of all, these are multicultural corridors and involving a host of legal systems and economies. We have civil law, common law, religious, tribal, customary legal systems interacting. And if history has taught us one thing, is that this is normally a recipe for disputes. And to avoid that, there must be sort of intergovernmental, supranational initiatives to try and mitigate the impact of interaction between these legal systems. One example that pops to my mind, when the UK and France were engaging in the Channel Tunnel, one of the disputes that have arisen regarding the contracting parts and the agreements relating thereto was what law will apply and how arbitral tribunals will decide this. And I think part of that was created the sort of the tronc commun doctrine, where we talk about common principles of legal systems. At the time, France and England, for those parts of the Channel Tunnel that are not on the English soil or the French soil. And if it is on the soil of England or France, then it's governed by their national norms. Now, with that in mind, my view of the BRI is as follows. As the future goes and as more projects take place, we know that there will be railways, we know that there will be maritime corridors, and a number of things we need to consider. First of all, how to reconcile jurisdictional differences on a substantive level. So we need to decide what law will apply or what common principles will govern. And my view is that if that initiative is going to be as successful as envisaged, one might create a sort of either bilateral or multilateral substantive texts that govern these projects. So you decide on the legal principles of interpretation, escape clauses, in addition to the termination, in addition to the project-specific agreements in relation to construction, financing, or otherwise. So we need to rethink the traditional perspectives about national norms when we discuss the BRI. Because if we're going to subject BRI projects that pass through several countries, so not wholly, let's say, jurisdiction-specific projects, let's say pipelines or whatever that are going to be cross-border in nature, we need to consider a supranational set of norms to apply. And in that sense, conventions or texts entered into between the BRI states will be extremely important. And we need to achieve harmonization amongst these texts, because one aspect of the project that will suffer difficulty will have an impact on the other aspects of the project in other countries. And for example, if you have a contractor operating, let's say, in certain parts of Russia, and then it passes through other parts to Europe, you will have problems if we do not reconcile those differences and have proper norms in place. There are, of course, issues between the civil, common law, religious laws, distinction and diversity of legal systems that exist. And to rise above this, as I mentioned, we need to find common grounds and common principles. And this is where comparative and international law helps a lot. And we have examples from the investor-state dispute settlement about treaties that offer certain protections, but in a commercial context, we can use this to create a set of legal norms that will govern the projects. In one arbitration I was involved in, not related to the BRI, but is definitely can be used, the parties have agreed that when the tribunal considers the dispute and decides it, they have to take into consideration the project at large and the cross-border nature of the project and the importance of the overall development objectives. I think the inclusion of clauses like that, first of all, will help uniformity in terms of decision making, reconciling any differences that may exist, and will help states achieve a proper resolution of disputes in a timely manner. Now, of course, when we think procedurally how this should be done, we know that there are hubs of international arbitration. And in Asia, which is a very rich and important continent, we know that there are many leading arbitral institutions on the continent. And I think these institutions need to pull their efforts together because the BRI is not going to be something that one institution will have exclusive jurisdiction to deal with. It's going to be cross-border in nature. And cross-continental, one important aspect that I would like to mention before I hand over to my colleagues to share their views is that cross-continental, Africa, for example, and we know that there is the Chinese investments in Africa are large and increasing. The states have engaged in modernizing their laws, be it bankruptcy, insolvency, or investment laws. This was part of the initiative discussed, especially in sub-Saharan African countries, with the Chinese government, to ensure that when the Belt and Road specific projects are in place, we would have an immediate possibility to proceed with the projects with a modernized infrastructure of laws that support the different projects that will take place, be it construction, supply, services. All these projects definitely will kick in. And as a matter of fact, it is important that we put in place proper legal provisions, legal instruments that deal with the specificities of these disputes. So my takeaway of that, I don't think that national laws in the traditional sense will be dealing specifically with cross-border projects. It's going to be more of supranational instruments or modernized instruments tailored for the BRI. And also the funding aspect. So far, the Chinese financing institutions are taking the lead with the financing, but it is envisaged that many more financing institutions worldwide will have an interest in joining forces to fund projects. And this, of course, will have its own host of legal challenges and prospects as the situation and as the projects unfold.
Dr. Mohamed, you are talking about a supranational effort. That means you're talking something like the UN or something like that, coming out with harmonized instruments. To what extent can we use, let's say, UNCITRAL? because, for example, UNCITRAL is also a negotiated legal soft instrument, but the model law is there, the rules are there.
That's an excellent question. Let me say the following. The UN is definitely an international organization, a global organization. My view is not more on the organization side, the creation of an organization, but it's more on the use of supranational texts. You mentioned, for one, the UNCITRAL, which is very helpful. What I see is that, of course, the UNCITRAL has been providing very helpful texts that deal with matters of procedure across the board, like including as well public-private partnership, including e-commerce, including in the specific context of arbitration rules and the model law. But what I'm thinking about is something more substantive. Among the few substantive conventions we have in place is, for example, the Vienna Sale of Goods Convention. The Vienna Sale of Goods Convention has got substantive provisions. And this is my view. For the BRI to have a uniform, harmonized set of norms that cut across legal systems and rise above the specificities and differences of legal systems that span the BRI itself, we need to think of an instrument that has substantive norms. And the Vienna Sale of Goods Convention could be a role model in this sense. So I would not be surprised to see China, as I mentioned, has signed MOUs with 138 states so far. So these MOUs will have common core of principles about the goals, objectives, and purpose of the BRI. If we translate that into substantive set of legal norms, I would not be surprised to see a multilateral convention specifically dedicated to the BRI issues and could form the basis of a text that can be used for dispute avoidance, dispute management, and dispute resolution. I know people have not yet spoken about a multilateral convention to that extent, but this is to me the way that you can deal with the differences between legal systems and ensure that the different legal systems will achieve common goals and common purposes for the BRI initiative to succeed.
Right, Philip, what do you think in terms of substantive law and procedural law? Will this idea that of a multilateral convention overcome the choice of substantive law and also procedural law in trying to resolve the disputes or trying to prevent disputes?
Yes, thank you. What Dr. Mohamed just said is very interesting, very grand. And my only concern, I fully agree, but my only concern is that it would take time. If you talk about a multinational convention, how much time would it take? And the problem that we are having is actually rather immediate, if I can use the word. The project, the Belt and Road, it has already been rolled on for quite a while already. And of course, when the convention come out, the most useful time that we have to adopt it and so forth will be gone, if I may use the word. So I'm thinking if more immediate, then we try to grab something which is already in use. Now, when it comes to substantive law, we are really talking about little choice, which is already happening in this real world. A lot of international arbitration. For example, I saw the latest figure, SIAC, for example, 80% of the disputes are based on English law. But now I've also understand that Singapore law is talking about promoting its substantive law side by side with promoting Singapore arbitration. Now, it's not the best time to promote Hong Kong because of the political situation. But Hong Kong has always thought, or at least have the ambition to also promote Hong Kong law, which is in line with English law. But some of the fine areas will be more receptive to this part of the world. So I'm thinking of, now the other choice is, of course, civil law. Now, I do not readily have the figures, for example, in the Belt and Road countries most heavily involved, what sort of system of law would it be? So I'm really thinking of adopting something which is ready. So that is a question of promotion rather than creating it. And that might solve at least the short and medium problem. The grandeur thought, which Dr. Mohamed has just mentioned, could come in the longer term. So that's what I talk about substantive law, which is in a way important. But of course, the procedural law can be even more important. Because if you come to think of it, as far as I know, the PRC contract law, Chinese contract law, and English contract law, or Singapore or Hong Kong, in fact, the general principle is not really that much different. It's still rather alike. It's really the fine details. Now, the procedural side, again, it's very much dominated by common law and run in a very adversarial manner. Although there has been quite a bit of reform in English court, for that matter, Hong Kong court as well, after the civil procedure rules, and I think a lot of things have been addressed, but I don't see coming through in international arbitration, like expert evidence, like the inequality of arms and so forth. These are still very, very tough in international arbitration as far as I can see. Now, it's not really suitable as far as I can see for Belt and Road, which is a different mentality or different situation or different environment. So how should we go around with that as well? The procedural law and the system of dispute resolution is, in my view, an even more important area than the substantive law, although I admit that both will have to go hand in hand.
But Philip, most of the companies that will be actually, I mean, let's assume that it is a Chinese bank that is lending to a state-owned enterprise to finance the construction of the project, and it may be a soft loan coming through. And then it could be the Chinese contractor who's having many subcontractors that are local who are actually doing the work. So, they may be more familiar with the Chinese legal system rather than an English legal system or English law. So how would that be handled?
I of course agree, but of course, firstly, if you cannot take the whole package of Chinese practice and Chinese mentality and actually put it in the Belt and Road and enforce in all other places. You cannot do that. And China would not have, I'm not sure if they would have the intention or even the power to do that. Right. So there has to be a new system of compromise, if that is the word. But it will give rise to certainty. It will give rise to equality and receptive by most, if not all, of the participants of the Belt and Road Initiative. And then it will have to go through training. Training is very important in order to bring people to a common understanding or common norm of doing things. I think that is my view.
Yeah, thank you, Philip. Dr. Lee Hu, we are aware that many of the countries that the Belt and Road Initiative is passing through are relatively emerging. That means basically their legal infrastructure is suited for themselves. And in China, we have an institutional arbitration system, which is quite well entrenched, where all the arbitrations in China, except for now I can see a certain amount where foreign institutions are allowed to actually carry out arbitration and their awards are being recognized. But generally, for example, in China, it will be institutional arbitration, 250 arbitral commissions handling that. And then these companies that are coming out and investments are coming out are going to sometimes across jurisdictions that emphasize more on ad hoc arbitration. You have like countries like Pakistan, Iran, they don't really have strong institutions. So how would this issue be handled in terms of a safe seat? You know, because I'm quite sure in China they feel that it is a safe seat if they handle one of the commissions. And outside of that, of course, we have the traditional safe seats like London, ICC, Singapore, Malaysia, or whatever it is. But what about in those jurisdictions which are emerging with no safe seat or perception of that there's no strong arbitral institution? Dr. Liu, do you have any views on that?
Thank you, Professor. In general speaking, as to the first topic we discussed just now, I in principle agree with Dr. Mohamed's idea. International convention may be needed for BOR disputes. I also agree with Philip Young's idea that procedural law will be playing an important role in especially the field dispute resolution. In my mind, you know, at present, it's nearly impossible for us to have one legal framework in BOR projects. The projects are inevitably involved with different legal systems and different rules of law, both procedural and substantive. As a safe seat, you know, I think but the seat is only safe in a comparative manner. It's desirable that the BR projects are based in a state which owns healthy legal systems by which, you know, the legitimate interested parties may be better protected. You just mentioned, Professor, the ad hoc arbitration in China. Yes, under Chinese arbitration law, you know, ad hoc arbitration not allowed. The Chinese arbitration only allows institutional arbitration. But it does not mean it's impossible for you to have ad hoc arbitration in China. It depends on the provisions of the arbitration clause or arbitration agreement. For example, the parties may agree arbitration in Shanghai, but the law applicable to the arbitration clause is Hong Kong law or English law and other laws of the country which permits ad hoc arbitration. It'd be okay, it'd be fine for the parties to have ad hoc arbitration in China. However, in BOR projects, if the parties, especially foreign parties, want to have ad hoc arbitration, you will also choose the place of arbitration other than in China, for example, Hong Kong, or some Malaysia, France, London, etc. Yeah, it's also impossible. So also, you know, in your introduction, Professor just mentioned which legal system is more adjustable to the BOR. I think the question will depend on the state or region where the BOR project is located. The legal system of that state or region will play an important role in the operation of the project. Of course, subject to the mandatory provisions of the local law, the parties of the BOR project contract may choose the foreign law they think appropriate to be applicable to a project. Thank you.
Thank you. Thank you. That leads us to the next topic, Philip. We wanted to actually discuss the role of arbitral or ADR institutions in the BRI. I think we have touched on some of the things. Would you like to actually start off the discussion so that we can continue after that?
Yes, Sundra. The next topic, which is really about the arbitral institution and of course education training side. Now, firstly, the institution, that is part and parcel of what I've said. I thought this area is very important. which link it with the procedural law. I'm trying to look for a system which is more receptive to the Belt and Road participants and countries and jurisdictions. I've been thinking, firstly, choosing between the institutional arbitration and ad hoc arbitration. I would thought institutional arbitration will be much more suitable because most of the participants are from countries which are do not really they are more familiar to institutional management. If I use the word, the ad hoc arbitration more used to people, say, with the common law background, and there is, of course, very comprehensive and practical and meticulous arbitration law, which can really support an ad hoc arbitration in order to make it work. So this sort of situation is not exactly in Belt and Road jurisdictions. So I thought I would go for the arbitral institution. Now, we do have a lot of institution arbitration in Asia. We have Hong Kong and we have Singapore. We have KL. And in fact, most countries will have their own arbitral institution. Now, the problem is with those institutions, I would have thought is also difficult for Belt and Road in the sense that it has to be trusted by most, if not all, of the participants in Belt and Road. Whenever they put in an arbitration seat, including the arbitral institution, then they wouldn't feel offended or suspicious or concerned or even unfamiliar. Now, that to me seems to cut down a lot of choice. So how about rather than a national arbitral institution, we go for a transnational one. The two that I come to my mind would be, for example, exit. Now, by exit again, can we create a similar institution like exit just for the Belt and Road? Another one is, of course, less to do with politics, but more to do with commercial, is the ICC. ICC, I would regard it as the only successful institution which is not attached or associated with a certain country or certain jurisdiction, and is really international. The only thing for Belt and Road to be taken over by ICC would be it is a little too Western, if I use the word Western, because Belt and Road, after all, is actually this you may say this part of the world, Asia, Africa, and of course it is an initiative that has been taken off by China. Now, is it possible to have an institution like this, of course, with perhaps even managed by people who are receptive, not from mainland China, but from Malaysia, for example, from Indonesia and so forth, create an arbitrators list which will be more receptive again to the Belt and Road, but of course it will be drawn internationally. So that is something which I'm wondering, and I open up for discussion on this area.
Right. So if this institution is going to come about, or a number of these institutions that's going to come out, what form do you think it will take? There was a suggestion it should be a transnational, supranational kind of institution like ITSE. You did suggest that at the beginning of this talk, that, but is it feasible to do that for the Belt and Road Initiative with these countries and and sitting side by side with ITSIC and PCA and ICC?
It's just thinking. I'm not. I just feel that it would be quicker than having a say convention. We talk about substantive law. If you create an arbitral institution, it can be a lot quicker, and you need promotion anyway.
Yep.
So that people will put it in the contract. Now, if you have a blessing of this kind, then you will have the blessing of the government to make sure Belt and Road contracts will enter with this institution. So it's really for a group of people with the support of, or at least blessing of the government to actually to do that. People who are already competent in arbitration, who has the reputation and so forth. You form an institution. It's really not that difficult compared to passing an international convention. Now, in that case, you have people with the like mind of yours, Dr. Mohamed and so forth. And now, then it might be able to actually find also a system of procedural rules. If not the law, we cannot change the law that easily, but you can have a rule which will make it less, for example, less inequality when it comes to arm. You can be less adversarial, which again, I think is more receptive to the mentality in this part of the world. So that is the way I'm looking forward, and I like to draw and indeed invite views to see if that is more practical. I wouldn't say use the word practical if I withdraw that. It's going to be quicker than the other visions that we have.
Philip, you mentioned about education and training to actually to get people receptive and able to actually utilize whatever is being presented as an opportunity, both lawyers and users and also governmental officials and others. So who should carry out the focus of this kind of training and education?
If the institution or the organization which we've been talking about, I've been talking about, can come through. Now, of course, education can go side by side with that institution, or it can be done by anybody. Now, I quite respect the vision that you have. In fact, probably 10 years ago, I've already heard you speaking of try to grow the education in Asia. Now, I thought when you become the president of Chartered Institute of Arbitrator, even before that, I thought you, or sometime around that, you have been talking about the high expenses of those courses, very costly. And it is difficult to bring to quite a lot of countries in Asia. I thought at that time you talk about Thailand and Indonesia and so forth. Now, that strikes me. And of course, later on, you even try to go on to start up with education for Asia, to run courses and so forth. Although it didn't actually move ahead as fast as you wish or I like to see, but that is something which I thought must go hand in hand to increase the awareness of whatever system which has been built in for Belt and Road, to reduce disputes, to prevent these disputes from arising, or to actually to bring early and amicable conclusion to a dispute whenever it arises. So the education can really go side by side with the organization or institution, or even is a question of staffing the institution. When you have enough people, you can even run it under one roof.
Right. What about accreditation, allowing a certain standard? Dr. Mohamed, who do you think should be doing that in the Belt and Road? Or should it be like what is happening now, various institutions, some prominent, some not, some are educational institutions, some are arbitral institutions. Everybody runs, I mean, a multitude of things. So there's a hierarchy developing. So what do you think, Dr. Mohamed? Sorry, thanks a lot, Philip.
Thank you so much. And thanks, Philip, for the very insightful contributions, and Dr. Wu as well. Let me say the following. I'll take a step back by saying the following. First of all, in terms of arbitration or institutions, for the Belt and Road, I have quite some strong views that I'm going to share very candidly. I don't think ad hoc arbitration is suitable at all. So ad hoc arbitration does not work for an initiative like the Belt and Road. You need institutions. And I fully support the view of Philip when he said that, well, the ICC is a truly global institution in a sense. I'm not sure about whether it's too Western or not, because as a matter of fact, they do administer disputes in Latin America, in Africa, in the Middle East, in Asia, very competently. And they have teams that are present there. So it's pretty much a very strong and a truly global institution in that sense. Now, apart from the ICC hat, the fact remains is that for these types of projects, we can expect three different categories of disputes or relations. Let's say relations. State to state, which is public international law. State to investors, which is private international law / public international law, so it's both. And commercial type of disputes. This could be private parties, contractors, suppliers, financiers, between themselves and with the states as private parties. So this is where national law may kick in with private international law. So with these three categories and three layers, the idea that Philip was mentioning, something like ICSID, let's take, what has been historically the case. ICSID was established in 1996 by virtue of the convention. So it was the International Convention for Settlement of Investment Disputes that created the ICSID. So that goes back to the convention point I was mentioning. I take the point about the time needed, but so far, if China has been very successful in having 138 MOUs in 5-6 years, I think it would not be difficult to go with the convention. Now, going back to the institutions, I think for these types of disputes, you need institutions that exist, that have a track record of dealing with these cases, that have an institutional and international dimension, that have the capabilities of making the right choices about arbitrators, administrative decisions for this initiative. And I think there isn't many across the globe that can claim this. The ICC definitely is one because of the breadth of and wealth of experience they have. But I also take the point, Sundra, that you mentioned about institutions on different continents and regional institutions. They will have a role to play, not necessarily on a purely transnational, but on the side in relation to the commercial disputes that arise between contractors and suppliers and states in this respect. And to that extent, we have a proliferation of arbitral institutions. And one of the things that I normally use, a term that I personally created, is competitive institutional competition. We have so many institutions, and not many of them are going to administer cases. The role will be reduced to training, providing or doing events. But to administer cases, you need a number of things. You need know-how, you need proper staffing, you need the ability to make the right choices, and you need permanent existence. To realize this, it's a vicious circle. You need to land a number of cases to be able to be recognized as this type of institution. But how will you get these cases? And I think the Belt and Road Initiative is interesting because, for example, African institutions on the continent, and China, for example, has established joint efforts of joint institutions in this regard, are indeed trying to arm themselves with the needed expertise to offer the services for the Belt and Road and otherwise. Examples, of course, you have the Kigali Arbitration Center, you have the Nairobi Arbitration Center, you have the Cairo Arbitration Center, one of the sister institutions like the Malaysian or the Asian International Arbitration Center. But the idea is with these institutions, and you have rising truly international ones now like the CMAC in Casablanca, to be able to do that, you need to showcase, as I mentioned, the elements of expertise, know-how, and ability to administer those cases. And within the realm of the Belt and Road, I see this again proliferating and taking place through combined institutional efforts. There will be a sort of an agreement amongst institutions to, or a protocol on the administration of this. And some institutions, for example, let's say SIAC or Hong Kong, which are great institutions, ICC, LCIA, and others, they may have agreements with other institutions so that the hearings or the proceedings are hosted in certain seats. So this is another dimension where institutional collaboration and cooperation can coexist with the competition. So with that in mind, I'm not so sure that we need to establish a new institution from scratch, because again, if you establish it from scratch, how will it acquire the trust and confidence of players to be used for such a colossal initiative? What I think is you need to bring together institutional efforts by leading institutions to establish a framework or a protocol on the administration of the Belt and Road. And this can pave the way for what we can consider then as uniformity in the approach to administering procedural aspects. Appointment of arbitrators, creating, for example, a pool of BRI dedicated arbitrators, because we expect these disputes to arise and you will need expedited resolution thereof, by the way. And so it needs time. Exactly like the expedited proceedings established by many institutions. For the BRI, you need to have this protocol in place. And also on the substantive law, and I hear Philip and Dr. Lee Hu's point is the convention may take time. But for example, let me test this. The Indo-China Peninsula Economic Corridor, which is expected to be an ocean route connecting Vietnam, Thailand, Laos, Cambodia, Myanmar, and Malaysia. I doubt with this type of corridor that is Asian-centric, you will have, for example, people opting for English law because of the diversity of the legal systems. Now, Singapore may offer a very lucrative, or Hong Kong could be an option. But here there are political and sovereign considerations in play. And that's why you need to have this common core of substantive principles that these institutions or arbitrators will be able to use to resolve these disputes.
Dr. Mohamed, it's quite interesting that you say that it will be quite difficult and it's easier to bring a number of institutions together and find a common framework. Let us say that someone has an idea that we take it as a project, just like what happened after Bretton Woods. It was a project by the Allies to reconstruct Europe. And they came up with the IMF and they came up with the World Bank, and it's a natural outcome of it. So now we have a reconfiguration of the economic arrangements again. And can there be a concerted effort? That means investment, initiative, recruitment of personnel, creating a structure totally new. In fact, maybe I'll address this to Dr. Lee Hu. From let's say the person or the group of people, all the countries that are involved in the Belt and Road, because all the existing institutions have their own agendas and they have their own priorities. To get them to talk a common language may be difficult. So perhaps can there be an initiative in the Belt and Road countries itself to set up a new institution to actually deal with disputes in all forms of disputes, all forms of project management?
To hand it over to Dr. Hu, I think will be the best person to address this. One very important distinction we have to remember is that the rebuilding of the world following the Second World War by the Allied forces, these were the winners, the people who won in the war.
Yes.
Whereas with the Belt and Road, it's not after a dispute or a violent or sort of war. It has an opportunity to bring all those with vested economic, political, legal, commercial interests to take part of this. And this is where a truly global initiative can be used as a platform. Dr. Hu, I think it's best for you to step in now.
Thank you.
Well, thank you, Professor. As the topic, it's very interesting. By my observation, to the structure of ADR institutions, by my observation, on one hand, more and more institutions are established actually. For example, in Vietnam, it has established set up the so-called Pacific International Arbitration Center. And Cambodia also has established its own arbitration center. But on the other hand, I noticed more and more institutions are providing multi-layer services. For example, many institutions besides commercial arbitration, they're also providing with parties mediation and other kind of ADR services. So that's a fact. I also agree with Dr. Mohamed. Some institutions are administering arbitration and other ADR services, but other institutions are providing training course and training program for the parties. But for the institutions new established, I think if they want to administer cases, it needs time to build its own reputation. It shall have the professional panelists, international rules and facilities so as to deliver excellent ADR services. And also, the new established institution needs to cooperate with other national, international institutions and to make international arbitration, international ADR a big cake so that they can win-win. So each institution may adopt measures to promote itself because competition is hard. So, for example, CIMAC will widely strengthen cooperation with international ADR institutions, so that we can explore and promote to establish bilateral or multilateral dispute resolution platform by which the listed institution may promote together while providing their ADR services. Also, the measures should be undertaken to promote the internationalization of CIMAC arbitration. We need assistance from Chinese Supreme Appeals Court so that one-stop diversified dispute resolution mechanism so that we can be listed in the panel of SPC's mediation or arbitration institutions so that we can have the support from the SPC. I think, as mentioned by Professor Philip Young, so the education and training is very important for ADR institutions. The training and the education and the training may be conducted by training courses, seminars, and conferences. I also think the training program may be conducted by the relevant professional institutions such as AIADR is appropriate institution to conduct a training program. I also think for AIADR to conduct training program, for example, if we want to have the training course in mainland China, AIADR may cooperate with Chinese professional institutions, for example, CTAC, CIMAC, or Chinese universities, so that we can have more and more Chinese experts to be trained under the program. Thank you.
Thank you. Thank you, Dr. Liu. The other thing that has been happening, one of the issues that have come up in dispute resolution is the costliness, timely, and all these things. And people are quite unhappy with rights-based approach, and there's a movement towards interest-based approach like mediations. So to what extent, especially I think in Asian culture, there's always an attempt to actually settle matters or to discuss informally, or to even prevent disputes before they do actually mature into a full-blown difference. So to what extent, Dr. Lee Hu, will dispute prevention in the BRI be a priority for the parties and the jurisdictions or the countries involved? And after that, how would the Singapore Convention on Mediation assist this process?
Thank you, Professor. Besides the reasons we discussed above, BOR project, in my mind, to some degree, because most of BOR projects are concerned with the infrastructure project. So such projects, in my mind, to some degree, involved with the political elements. So the parties, the country involved may, in the first place, seek to prevent disputes. No dispute is the best. So dispute prevention should be a priority for the parties, the country involved, in my mind. As to the Singapore Convention on Mediation, along with the coming to force of the convention on 12th September, the settlement agreement from the international mediation can be enforced in the convention state in accordance with the convention. This means that the mediation settlement agreement is legally enforceable under the convention. The convention has established a solid legal basis for the independence of the mediation as an effective approach to resolve disputes. So the future of the ADR is promising in that the convention has enabled impossible the parallel development of mediation, arbitration, and litigation. The mediation is likely to be adopted popularly in complicated BOR project disputes in the future.
Right.
The professor also think, the arbitration, however, also think the arbitration still remains the main dispute resolution mechanism in BOR disputes.
So we can't run away.
In essence,
no, we can't run away.
In essence,
right. Please.
Yeah.
Yes.
So the mediation results in settlement agreement, which is a compromise between both parties. Compared with arbitration, the mediation procedure is more flexible, and the settlement agreement may be reached or concluded in a manner that is so-called, which is not strictly in accordance with law provisions. So arbitration should be conducted strictly according to the applicable arbitration rules on the parties' special agreement, and with the final word of the arbitrator. So the arbitrator shall decide the case in accordance with the applicable substantive law, unless otherwise authorized expressly by the parties to act as amicable compositor. So in my mind, the role of the arbitrator of the word cannot be replaced by the parties' settlement agreement, and the arbitration cannot be overridden by the mediation. So arbitration has its own special value in dispute resolution. Right.
Philip, do you have any views on dispute prevention and in the BRI? Would it go beyond just what shape would it take other than what Dr. Lee Hu has spoken about?
I thought it's very much covered by us already when it comes to prevention of dispute. I thought it's very important. We always aim to reduce disputes anyway in this world and to resolve it in the best possible manner, amicable manner. Now, firstly, Dr. Lee Hu mentioned about mediation and arbitration. I'm not, I thought it's two different things. Arbitration is really international litigation. It is, but it changed from national court to arbitration. That's all. And I thought the adversarial type of dispute resolution nowadays, which is to destroy and kill the enemy effectively, that is adversarial. Now, may not be, I do not think it's very receptive to this part of the world, although we all run that system. And of course, Malaysia, and I'm from Hong Kong, will be more used to it because we grow up in this system. But you just come to think of it, it's not very receptive in this part of the world. And so would be the long-term relationship of the Belt and Road. So that's what I've been thinking. So the mediation and arbitration split would not make a lot of difference. If you can make arbitration, for example, by institution rules, to make it less adversarial. In that case, it will be close enough to mediation already. But nonetheless, it still would be able to enjoy the New York Convention and so forth, and the rest of the things. I'm very receptive, and actually is very delighted to listen to Dr. Mohamed as well. Maybe we don't need a new institution. We can have the existing institution, but most institutions has been sucked into the seat, the law of the seat. So there is a danger if it's associated to a particular nation or jurisdiction. Whenever there is change in the country, it will affect the institution. There is always the local interest in mind. Now, even talking about appeal on points of law, England wish to develop and promote English law, development of English law. And Singapore is now also thinking about the same. Now, I'm not saying it's a bad idea at all. I'm just saying that it always bear in mind of its own national interests rather than the whole Belt and Road Initiative. So any existing institution which has a really interest in serving this Belt and Road, whether it's from China, CETA, and so forth, firstly, they will have to disassociate with local interests. They might even have to have a different set of law. As I said, I hope to have a procedural law which will be less adversarial and geared to the mentality of the major Belt and Road jurisdiction, including China, of course. Now, then you have people who man or administer that institution. Of course, it includes a list of arbitrators would also have a like mind. Now, whether it's a new institution, which I agree fully with Dr. Mohamed, it doesn't matter. We can use the existing one and borrow the reputation that the institution had already built up. But nonetheless, it has to disassociate from the national interest or even the usual commercial cases that institution has been handling. Thank you.
Thank you. Okay, I think we have come to the end of our session. We are just spot on time. I have a question. Thank you so much. I have a question here from Mr. Chan, YK Chan. I agree and support a transnational institution to manage arbitration with its rules. I'm concerned about the substantive law to govern the contract and also the seat to which the court to govern the arbitration proceedings. Would it be left to the parties to agree the governing law and the seat of arbitration? Would the transnational institution put the governing law and seat into its rules unless there's a conflict with either party? It's a long question. Basically, he's asking about the seat of the arbitration and the rules, substantive law, whether it should be actually put into the arbitration agreement or the institutions to prescribe it. So any of you all want to answer that question? Mohamed?
I'm happy to, yes, I'm happy to kick off. I mean, again, I don't think it's for arbitral institutions to set the law governing the merits. They can provide guidance, whether they use choice of law or other criteria in terms of setting the stage of how the parties choose the applicable law. So that's on the role of the institutions and the merits. But of course, the seat could be, I've seen some interesting thoughts expressed in the chat regarding Switzerland, for example, where what I've seen Eric has proposed a reference to Switzerland, which does not have a colonial past, non-Anglo-Saxon neutral. And of course, Switzerland has been very successful, and we have great practitioners from Switzerland, both as arbitrators and as lawyers in arbitral proceedings. So Switzerland definitely is a favorite for being chosen as a seat or as a neutral legal system. But again, I think for the Belt and Road Initiative, the issue is the following. You have a colossal project that is global in nature, cutting across jurisdictions, inland and in sea, with projects that connect the dots to create a larger project or initiative at large. There is a vision for that, a purpose and goals and policies. These will be the overarching macro policies and goals and objectives that exist, and will inform any tribunal or mediators or any type of dispute resolution neutral
What happened? He's connected. He's connected. Right.
I think we have a connection issue with Dr. Muhammad. Right. Okay.
Off already, is it?
Oh goodness. So we have lost Dr. Muhammad. I think it's timely also. We have done 12 minutes over time. Originally we planned to do it until 4, but it's all right. I think what we will do is that we will if there's no other questions, I think I take the opportunity to thank our panelists, Professor Philip Yang, Dr. Hu, and Dr. Muhammad for joining us. I hope you all found this useful. Keep a lookout for our other webinars, quite interesting. We are trying to